If you are someone who likes to win an argument, or you know someone that likes to win an argument and you'd like to turn the tables, then this video is for you. Because I'm going to talk about how a barrister approaches an argument, because after all, a lot of a barrister's job is about winning the argument in court. But first of all, if you're new to my channel, don't forget to hit that subscribe button, because I'm a barrister who helps you understand law. So the first thing to understand is winning an argument is not by accident, it's by design. That means it needs to be well constructed, well thought out, and planned from the outset. You need to know what it is that you are trying to prove and how you are going to prove it. As the saying goes in that old-time classic, it doesn't matter what I believe, it matters what I can prove. So that's as good a place to start as any. It really doesn't matter what I believe. If I'm given an argument or I'm given a case to go and win, then I need to formulate these arguments and decide how it is I am going to win this particular argument. The important factor being my personal beliefs, my personal viewpoints, my personal opinions absolutely don't matter. Unless, of course, you are the outstanding expert in your particular field, then of course your opinion counts. In fact, very often experts are called to court for their expert opinion, and it is their expert opinion that often sways an argument. And for that matter, an expert opinion doesn't necessarily need to come along with qualifications, simply that someone has done something or has experience of something for a particularly long time could very well make them an expert in that field. But let's say we're talking about a run-of-the-mill argument and an expert opinion is not required. In that case, the fundamental thing you need to remember is opinions do not count. Opinions do not win an argument. So with that fairly sweeping statement as to what doesn't win an argument, let's look at what does win an argument. So to win an overall argument, you need to construct that argument. And the argument itself is going to be made up of several individual points which individually you can show and prove. And then taken together, all of those points lead to a logical conclusion that your overall argument must be true. And we can take this under three very broad headings. We can take facts and figures that you can show and illustrate, which individually will be taken as true. We can have authoritative decision, which in terms of the court system, obviously a higher court is an authoritative decision binding on the lower courts. And for my example here, we can have an objective assessment of the situation or the point in question. So running through those very quickly, if you've got a set of facts which by themselves are true and nobody can challenge it. Secondly, you might have an authoritative decision which is based on those set of facts. And thirdly, you might have an objectively reasonable argument as to what someone might think in a given scenario. If you prove each of these three things that individually are correct and someone will agree with, if they lead logically to a conclusion, then you will win the overall argument. So let's take that logic and apply it to a very simplistic scenario. Let's say we're talking about car manufacturers. We've got A and B. You are given the task to argue that A is better than B, and your opponent is arguing the reverse. And you may very well have an opinion as to which one is better. It might be A, or in fact it might be B. But as we said, your opinion doesn't really matter. If you are given the task of arguing that A is better, then you need to come up with some points that you can prove that logically conclude that A is better than B. So applying this strategy to this scenario, you may look at manufacturer A and B and look at their relative statistics. One of your arguments might be that the models produced by manufacturer A break down only 10% of the time compared with the models produced by manufacturer B. If this is an indisputable fact, then this is one of the points that you can win quite easily without much of an argument from the other side. There may well be statistics as to the impact on the environment. Manufacturer A may well again win in this department and hands down score you a point on the facts and figures column against manufacturer B. You can go on to look at all sorts of different facts and figures such as speed, fuel consumption, so on and so on. If you can find lots of points under this limb of the argument, again, you will have lots of points that you can prove in your favour. Then we come to authoritative decisions. In terms of cars, my thoughts turn to popular TV shows or professional reviewers or professional performers, for example. In this scenario, you may very well be able to get a popular TV personality to vouch that your manufacturer is better than manufacturer B. Again, we're turning a little bit to expert opinion in this field, but if you can weave that in as an authoritative decision as to which one is better, again, you're going to score points under this limb. Then we come to an objective assessment, what a reasonable person would think is most appropriate. I do this on my channel with you guys here. I was thinking of doing a live stream. I didn't know which day I was going to do it or which evening I was going to do it, but by way of a poll, more than 50% of you said Sunday is the best time for a live stream, so I'm setting those up, so make sure you subscribe for those because live streams are coming soon. So if whilst you're preparing for your argument that manufacturer B is so much better, and you put out a poll to thousands of people, and more than 70% of them say, hands down, manufacturer A is better than manufacturer B, for whatever their personal reasons are, it is an objective assessment that manufacturer A is better than B. So then you can probably see that any one of those individual points that you can score by itself is not going to prove that manufacturer A is better in this fictitious scenario. But if you score all of those points, then taken together, your overall argument logically follows that manufacturer A is better than B. Now I know that this is a hypothetical and slightly bizarre argument that I've put to you, but you can see how you can deconstruct what is otherwise a very simple argument, manufacturer A is better, and you can underpin it with facts, authoritative decisions, objective assessment, and there are a host of other points that you can prove and show that when taken together, you can win the overall argument. So the next time you're faced with an argument that you desperately want to win, there are two things you can do to ensure that you take yourself out of the equation and properly formulate and construct an argument that is more likely to win. The first of those is to take your emotion out of the equation, because it doesn't matter if you get upset, it doesn't matter if you get angry, none of those things are going to help you win the argument. And the second, with a caveat, is no opinions. Of course, unless it's an expert opinion that you are bringing in from outside. So no emotions, no opinions, just formulate your argument on individual points that you can prove that when taken together logically follow as to why you should win the overall argument. And this, in a very broad sense, is no different than what we do in court. We are given an argument to win in court and we need to prove various facts. We need to prove that A happened, we need to prove that B happened, then we need to prove that C happened, and taken together the logical conclusion must be that your argument is true. Let's take an example of theft and the way a prosecutor will look at winning an argument when prosecuting a case. A prosecutor will look at each of the elements of the offence. Then they will look at the facts and the law in order to prove each element of the offence. Then once each and every element has been proven, either to a magistrate or a jury's satisfaction as a finding of fact, then the prosecution will be successful. So looking at the elements of the offence of theft, there must be the dishonest appropriation of property belonging to another with the intention of permanently depriving that person of it. So let's take one of those elements, which will produce a segue into another piece of law that you might find interesting. The offence of joyriding, or taking a vehicle without consent, was introduced because one of the elements of the offence of theft was unlikely to be proven. This was because, thinking about the final element of the offence of theft, the intention to permanently deprive the other person of the property. In the offence of joyriding, the person dishonestly taking the car belonging to another person was not intending to permanently deprive the owner of it. They were taking it out for a spin and then going to dump it. This gave rise to the argument that one of the elements of theft could not be proven because there was no intent to permanently deprive the owner of the vehicle. Hence the introduction of the offence of taking a vehicle without consent. It no longer matters whether the person taking the car intends to permanently deprive the owner of the vehicle. They have done so dishonestly and therefore they are guilty of this new offence. So with my example, you can now see that in order to prove a prosecution, there are elements of the offence. Each and individually you need to prove. Each one by themselves will not win your overall argument, but when taken together, your overall argument is successful. So I hope you found that overview interesting. Drop your questions and comments below. Thanks for watching, and I'll see you next time.